Do begin. I've just left my papers upstairs because I was in such a hurry. It's a blue ring binder and the notebook and things inside it. Okay. So, but carry on.
My lady, my lords, it is my pleasure and privilege to be inviting this court to uphold the judgment and order of the Court of Appeal, which in turn built on the judgment of an experienced and now retired circuit judge. We seek to uphold the judgment essentially for the reasons given by the trial judge, but then modified by the Court of Appeal. The Court of Appeal correctly remitted it for consideration of what monies, if any, are owed and the counterclaim.
You lost before the trial judge, didn't you?
On the NOM
yes.
point only, yes.
Right.
On everything, on the consideration points, it was all successful.
Yes.
It was just with that modification.
Well, it's rather a big one.
Yes, of course, the case fell on that point at trial,
yeah,
but all the findings and reasonings of the trial judge in relation to everything else has then been built upon by the...
Very well.
Appeal, my lady and my lords, there is a choice between the old world and the new world, an imagined world and the real world. The parties
This sounds like jury talk to me.
My lady, it builds on...
It's not the sort of language that we have in this court.
It builds on the statement of case, and I stray from the statement of case as invited by the court to make these oral submissions. The parties were able to orally vary the contract, and the trial judge held that they did so. Miss Evans had authority, there was an agreement, and there was consideration. The Court of Appeal held correctly that clause 7.6 of the appellant's standard terms and conditions did not prevent the negotiated agreement from taking effect. That makes commercial sense. It implements the parties' intentions, which were for their mutual benefit. And we submit that that's the reason why this appeal should be dismissed. We divide our respondent submissions in two. First, we address the effect of clause 7.6, if any, on the licence variation. Then we will ask what, by way of consideration, was needed for the licence variation, mirroring the approach taken by the parties in their respective statements of case. What the Court of Appeal approved is what happens in the commercial world all the time. As Lord Griggs rightly observed in the submissions of the appellant. A number of retailers are renegotiating their retail leases at the moment. There's rent holidays that they're asking for. There's reschedule of their actual rent liability. It may be that the landlord gets monies early. It may be that the landlord gets monies late, as Lord Sumption observes. But both of those can be considered as consideration. But first, before going on to the submissions, can I deal with some updating material and comment on the factual basis of the appeal? We've recently filed with you, my lady and my lords, some further extracts from Chitty, which will assist in the approach to Folks and Beer, and also comment on what the current authors of Chitty's views are of the Court of Appeal decision in this case. We've also handed in a copy of the Harvey McGregor Code. In our statement of case, we had thought that that was a Law Commission report, but in fact it wasn't pursued by the Law Commission, but was published by Mr. McGregor himself.
Yes, and the date?
Of publication
Yes.
is 1993.
But it must have been done
It was done...
decades before that.
It was, yes. I think it was started in about 1968 and went to the Law Commission in 1971. And then, perhaps more pertinently, are the other emails that were relied on by the trial judge in making his findings of fact, but were not included in the original core bundle, and that is part of the additional volume, my lady.
Yeah.
Yes.
Can I explain what is in the...
This, which arrived on our desks earlier today.
Yes, it was sent in to the court a few days ago.
Yesterday, the day before. Yesterday.
Have you got that?
Yeah. Somewhere.
Well, it only arrived on my desk this morning.
Yes.
Probably arrived on mine too, but if so, I haven't noticed it and I haven't got it.
I haven't got it either. No.
It's this one with two tabs, is that right?
Yes, it runs
With the
to...
additional-
Yes,
It's the
that's right,
revised
my
payment
lord.
schedule and
Yes.
some emails.
Yeah.
My lord, yes. And that was crucial evidence that was before the trial judge and assisted in his determinations of the findings of fact.
Well, Mr. Paget, it may be my fault. If it is, I'm really sorry, but I haven't got it. Could I have a copy, and the same may go for my
Yes,
Lord
it does,
Sumption?
Yes.
So I apologise. I'm sure it's upstairs somewhere.
Well, we'll share if necessary. Thanks very much, David.
Yes. Because I got that. Yes, perhaps it's a spare.
Thank you very much. Thanks. I've never seen this, no.
I'd expected you to see this
Never seen this.
if it could have come, because it's quite... But it wasn't on
Thank you very much, David.
it wasn't on my chair when I arrived this morning.
Oh, wasn't it?
Across the morning.
Oh, did it? Yeah. Oh, perhaps it's in my room.
I saw it yesterday.
Yeah.
Anyway, never mind.
Well, lady, the relevance of it is if we look at the findings of the judge, his judgment is at page 128 of the core bundle. And the agreement, discussion of the agreement starts at paragraph 5, but then goes on to paragraph 8 on page 131, lady.
Yes, he quotes a lot of emails.
Exactly. And you did have just the first one, which was, please confirm if this was acceptable to you. And you didn't have the email of 1558, which was after the oral agreement, confirming it, which is in the middle of paragraph 8. Hi, Natasha, thanks for your patience and acceptance of our payment schedule. As per the schedule, I will make an immediate payment of 3,500, which they then...
Mr. Paget, I think we noted that we didn't have all these emails.
Yes.
But you've now given them to us.
Yes.
Do they add anything to what how the judge summarised them?
They don't.
And when you say confirming, it wasn't her confirming, it was his confirming that she'd confirmed.
In what context, my lady? In the first email or the
First
second?
email, please confirm.
Yes,
Then there's a conversation
yes,
on the bus.
yes,
And then he sends another email saying, thanks for your acceptance.
yes.
So he's confirming that she's confirmed. There's
Yes.
not an email confirming by her.
No, that's correct.
No.
But what there is then,
But there's no appeal against the judge's finding of fact that there was a concluded agreement, oral agreement.
that's correct, and that it is evidence in writing, including these emails and the repayment schedule.
He didn't find that it was an agreement in writing, did he?
He didn't find that it was an agreement in writing, no.
No.
You're not suggesting that it was.
No, but it was evidenced. This goes to the evidential point that Lady Justice Gloucester summarised and then is endorsed in Globe. What do you need to satisfy the court that there has been a variation? Well, if you've got an email trail detailing it, then that is going to be persuasive evidence, and that was persuasive evidence for the findings of fact by this trial judge. And that is in the additional bundle at page 6. Is an email from the appellant confirming that the £3,500 had been paid. So there was a...
Well, none of that's in dispute, is it?
My lady, no, it's not in dispute. But you didn't have the evidence upon which that had been based previously in the court. And then finally there's an email detailing the understanding, and that's on page 9, 27th of March 2012, that again is referenced in the judge's decision. Those, of course, all relate to the licence agreement, and the licence agreement is at page 137. This was a licence agreement of new accommodation. The parties already had an ongoing business relationship. Indeed, the respondent was one of the longest term service users. They'd been using it for 7 or 8 years, but just in smaller accommodation. They were moving up to larger accommodation. And they sought a fee, and a term was agreed. And then this invoice was sent, and it's not signed by the parties. And on page 139, a lady, on the back of it, standard printed terms and conditions of the appellant. Included in those, all of the same size, is clause 7.6.
Well,
So
I
there
hope
was
in
no,
the original it's actually legible.
all the photocopies I've seen are poor.
Well, it's even poor when it's magnified on the screen.
Yes. So that was sent across. It wasn't signed by the parties, and then there was no battle of the forms. And it's a surprising term in the context of an unsigned agreement. It required that any variation could only be effected by a more formal way than the original agreement. It required an additional element, signature of both parties, not present in the original agreement. It was counterintuitive that any slight variation of the agreement needed more formality than the actual agreement itself. So it's not certain, really, whether such a surprising term was ever actually part of the contract. This was not the way the case has been canvassed below, but the appellant took no reasonable steps, indeed took no steps to draw clause 7.6 to the attention of the respondent. It's an unusual term requiring a higher degree of notice. It's not in capital letters, it's not in bold, it's not underlined, it's just incorporated as a clause in the standard printed conditions. That's arguably not a rigorous step taken by the appellant to, nor was there any covering note drawing specific attention to clause 7.6. But what that factual context does do...
Do we know whether the same term had been included in their previous licence agreement for the smaller property?
We don't know, albeit I'm assuming it probably was, seeing as these are standard terms, standard printed terms. But what that factual context does do, we would submit, in this case, is determine the amount of evidence that will be needed to satisfy any oral variation. It's going to vary on a case-by-case basis. And Lady Justice Gloucester's test, the evidence established that such a variation was indeed concluded. what evidence is needed. Well, that would be far less in a situation where the term was never brought to the respondent's attention at any stage and was buried in the standard terms printed conditions than in a situation like Globe, by contrast, where there was a complex commercial arrangement following detailed negotiations. In Globe, the contract extended to some 8 documents and 4 appendices. And yet still there was a finding that you could orally vary that. Where the oral agreement is much less formal, the evidence needed to prove a bilateral discharge will be less than where the original agreement was that much more formal. So let's turn to the effect of clause 7.6. The Court of Appeal's decisions in this case and Globe are correct to recognise the autonomy of the contracting party as determinative. There is no reason why those parties should have a special or heightened status when they are entering into the contract that then irretrievably binds them thereafter. And to illustrate that, I'll take up Mr. Darton's invitation of extreme examples. If you have, as the director of a firm, a masochist who, in his printed terms and conditions, requires that any clause of variation must be signed in blood, he's replaced as the director, so there's the appropriate authority to vary, and the new director is not a masochist. She negotiates a variation, but does not require the signing in blood, although she could have insisted on it if she wanted to. On the appellant's case, that variation would be ineffective because any variation would always require a signature in blood. Or the director of the firm is an aesthete. His standard terms of printed conditions require any variation.
There might be a public policy element to that.
To the first one, there might be. I couldn't find it, but there might be.
Well, there is a certain play that kind of springs to mind.
Yes, that comes in.
Well, we can't test the correctness of propositions like this by imagining such impossibly remote examples. I mean, there is no proposition which can't be undermined by a sufficiently extreme or extraordinary example.
Well, these highlight the argument that the appellant is putting forward, that once you've agreed something, a nom clause, and it may be in a very eccentric nom clause, you can't go behind it. Of course you can go behind it. You can either rely on it, or you can agree not to rely on it. You can have a mutual discharge or overridden of that clause. Another example which doesn't bite on public policy, the director may require, as part of the nom clause, that any variation is not just in writing, but in mauve ink. He's replaced as the director. The new director lives in a greyer world, and she doesn't require the variation to be in mauve ink. It could even be written. On the appellant's case, that variation would be ineffective, because any variation will always require mauve ink. An example of location rather than form. The director is an acrophile. His standard printed conditions require any variations to be agreed at the top of Snowdon. The new director lives in the Fens. She's an acrophobe. She negotiates a variation and is happy to follow that and rely on that without a trip to Wales. On the appellant's case, that variation would be ineffective. These examples would all still work with the original director in place, but just choosing to bilaterally discharge the eccentric variation clause. These examples illustrate, that business efficacy does not all point one way. One of the appellant's arguments is having nom clauses assists with business efficacy, but they don't, we would submit. They don't promote efficient legal and business relations. Contracting parties do not have a heightened level of commercial sense of their own benefit when the contract is agreed. The opposite is true. Business efficacy should allow parties to freely negotiate and vary terms where it is in their mutual benefit to do so. Here, that's exactly what happened. It made commercial sense to both sides to do a deal. If the contracting party does not want to orally vary, they don't have to. They can rely on the nom clause. There are adequate safeguards. Only someone, and this addresses the appellant's concern, that in large organisations, people in lower positions of authority may be able to vary written contracts orally. That's already addressed by the fact that you have to have the authority before being able to make that. And there was a finding of fact here that there was adequate authority. The nom clause is a clause for the parties, and then if the parties don't want to rely on that clause, they don't have to. There was ample contemporaneous evidence, written evidence, to support the oral variation. That addresses the concern that the appellant has of summary judgment applications being resisted because the defendant asserts there was some oral variation. As my Lord Sumption has observed, that practical concern shouldn't determine this issue of principle. But in any event, there's no evidence that that is something that is actually happening. The same test would apply in relation to summary judgment. If there's an absence of reality, summary judgment will all be ordered. If all they can do is assert, oh, well, there was an oral variation, without the adequate evidential basis, that's not going to pass that test. Here, of course, there was the contemporaneous evidence, the actions of the parties, that pointed clearly to the fact that there was an oral variation on the 27th of February 2012. There's no risk in these cases, actually, to the claimant being held to ransom. If a defendant is making up an oral variation and has the foresight to send an email at the time they hope an oral variation will be found by the court at a later date, well, the landlord or the claimant is immediately going to respond to the email saying, well, this is all rubbish. We haven't agreed anything like this at all. You are wrong. That's not what we've agreed. But there isn't any emails like that in this case. The appellant says, in this case, that there is no injustice for clause 7.6 to have been complied with. That is just chance in relation to the clause 7.6, that it is not onerous. It could easily have been an onerous clause. The parties were perfectly able not to need compliance with clause 7.6, and it is arguably an injustice to have required that when parties are moving quickly, agreeing something and acting upon it as soon as they have agreed it. People in business, when negotiating, need to have confidence that what has been agreed is binding, and then they can act on that. And it would create uncertainty if all that you can rely on is equity to fill that in, because it would then distinguish the person that acts immediately upon it from the person that has to act for an uncertain period of time before it becomes unconscionable to go back on that. There's no need to rely on equity and unconscionability, because the contracting parties mutually varied that term. There is no injustice on the appellant. The appellant said there would be no injustice to require compliance with clause 7.6, but looked at the other way, there is no injustice on the appellant, because the appellant agreed to the terms and did so in its commercial interest.
Well, that's the finding in this case, but in many cases there may be a dispute as to whether agreement was reached on the revised terms, and if it was, exactly what the revised terms were. And the advantage, or one of the advantages of clauses of this kind, is that is to avoid such disputes.
My Lord's completely right, but those are matters of evidence that
Well,
it is a matter of evidence whether...
It is a matter of evidence whether an agreement was reached, but there is an obvious purpose for including a contractual provision which limits the kind of evidence that can be used in support of an alleged variation.
But in those circumstances, the contracting party is perfectly able, at the beginning of those negotiations, to say, this all needs to be in writing because we've got the nom clause. Where they don't rely on that as part of the mutual negotiations, it is unattractive to then say, once everything's been agreed, we've got an oral agreement, and the parties are relying on it and act on it, and it's all in our commercial interest, to then say, oh, wait a minute, we've got this nom clause. That's exactly what happened here. It's that someone higher up in the organisation didn't like the deal. Then, subsequently, oh, look, we've got this nom clause. Let's rely on the nom clause.
I mean, that is another well-established commercial advantage of including a nom clause. It means that the requirement of formality makes it more likely that the internal procedures on either side will be complied with, so that you don't end up with a situation where there may be no actual authority but is ostensible authority, which is an unsatisfactory state of affairs for many businesses.
My Lord, yes. There is a completely understandable rationale to have the nom clause in there, but that is not the issue in appeal in this case. That makes there are manifest commercial reasons why nom clauses are placed. And it is incorrect for the appellant to say that the result in the Court of Appeal means that nom clauses are unenforceable. Of course they're enforceable for all those reasons and general contract law. But if a party decides to bilaterally discharge that term because in the specific circumstances of those negotiations, it's in their commercial interest, they can do so. Just like the fact that it's in their general commercial interest for all those reasons that Lord Sumption says, for a nom clause to be there in the first place, enhancing certainty, etc. But that can't bind them irretrievably thereafter. There is no injustice to the appellant because this is not a duress case. It is not a case where Mrs. Evans was forced into agreeing anything. And that is the opposite end, perhaps, of the spectrum from the initial implementation or agreement of the original contract with a nom clause in. There's the safeguard for the parties. And then at the other end of the spectrum, if one party is putting up economic duress on the other party, then the agreement or actions arising out of that are not binding. But in the middle, where the parties are doing a deal which is in both of their interest, there is no reason and requirement to then revert to the original nom clause. We would submit that the ability to vary enhances efficiency between the parties. The parties want to know that they can act immediately and want to know that the variation is binding on them. I turn to the Globe case, just briefly to make that point out and to address the evidential concerns that the appellant has highlighted. That's at tab 3 in the paper, volume 1 in the paper bundles, and it is at (288) in the electronic versions. Paragraph 98 needs to be considered because it's said by the appellant that equity can solve all problems here, that law should not entitle the parties to vary, but equity can intervene. Well, equity was specifically advanced as an argument in the Globe case, but the Globe case was determined on law. Paragraph 98 it shows that that was being advanced by the party. The concerns that the appellant has in this case were also advanced and answered in the Globe case at paragraphs 108 and 109 of Lord Justice Beeston's judgment, which is page 95 in the hard copy and page 291 in the electronic version. Those are all questions of evidence. And Lord Justice Underhill was considering questions of evidence when he talked about a halfway house. That's at page 97, paragraph 116 in the hard copy, which is at page, I think it's page 293 in the electronic version. At the bottom of paragraph 116, he is considering the flexibility of the parties. The parties can rely on the term if they want to. They can resolve from the term if they want to. And then the penultimate two sentences, but the arguments in favour of a flexible approach are also strong. In the end, even if it were desirable to treat provisions of this kind as entrenched, I cannot see any doctrinally satisfactory way of achieving that result because of the autonomy of the contracting parties. I have considered whether there might be some kind of halfway house which made it formally more difficult for a party to establish a non-conforming variation, but none was suggested in argument, and I cannot see any that would be of realistic value. So you can see there that he was clearly considering evidential tests, not the importing of equity into law as a halfway house, because he upheld the decision in law. The other equity cases that have been advanced by the appellant are also distinguishable, or in fact are law cases. The Emery case, which is at tab 22, was a case which in the electronic bundle is at page 543, and in the hard copy is 327. There was no agreement. Paragraph 6. This was where there was a mortgage. They get into arrears. They talk to their mortgage company. Can we reschedule, etc. There was no agreement. The trial judge is finding, moreover, the letter of 8th of March can only be properly construed as suggesting that before any further steps were taken by the bank in relation to the account, Mr. Smith would be in contact once again. And that's reinforced at paragraph 10 on 328 electronic 544. The judge held that there was an arrangement that Miss Emery would continue to pay the £700 per week while the UCB, the bank, considered its position. The judge rejected the submission of Mr. and Mrs. Emery that the arrangement would continue until the arrears were paid off, but held that it would continue at least until Mr. Smith reverted to Mr. and Mrs. Emery to alter that position. And then it was advanced by the parties on a promissory estoppel. But hence it's distinguishable from this case. And the Beattie case, the American case, although it's difficult to read the report, it appears to be the opposite, really, of an equity case. That's at tab 15 of the bundle, and it's at page 227 in hard copy, 441 in electronic. This was a situation where either the money's advance would be a loan or it would entitle the party to, I think, own some of the other business. And the party lending the money agreed with consent, and that's made clear in the extract that was relied on by Lord Justice Kitchen, which is in the middle of the left-hand column. But then relevant to the equity point is the sentence that begins after the citations. The plaintiff, we are told, did nothing on the faith of the consent, and hence it was argued by the defendant the defendant should be permitted to recall it. So it's actually not an equity case, because what they were saying is there isn't any change of position, there isn't any detrimental reliance, you've done absolutely nothing at all, so we can come along years later and change what we had agreed to back then. So it isn't a situation where there's unconscionability, but the court nevertheless decides that, well, it's too late years afterwards for the employer to cancel the consent and insist that the purchase be turned back into a loan. There's nothing unconscionable there. It appears more like a laches type case. And they
Then, of course, US law on this has moved on.
Yes.
And at some point, convenient to yourself, Mr. Paget,
Yes.
you might want to deal with the Uniform Commercial Code and internationally, the Vienna Convention on Contracts for the International Sale of Goods and the unidroit principles.
Lord, yes. Can I deal with them now then?
Please.
The code is at page 28, tab 28 of the hard copy version, page 391, and then 392 is the relevant part.
Is this electronic?
No, that's the hard copy version.
Right.
And I apologise.
Right.
Thank you. It's 608.
608.
Electronic.
Thanks. Yes.
This is not unusual in apparently, in American law to codify on an ongoing basis. And here we have, under 2-209, subparagraph 2, a signed agreement, which excludes modification or rescission except by a signed writing, cannot be otherwise modified or rescinded, but except as between merchants, such a requirement on forms supplied by the merchant must be separately signed by the other party. And that can be subject to waiver, and then we had a discussion before lunch about whether waiver was a legal concept or a concept. You see there, in that particular jurisdiction, they're saying you've got a signed agreement, so on the same status, perhaps anything that is to be varied needs to be at the same level. But then let's look at the other examples, and they are in the bundle, but probably the best place is to look in the McKendrick article itself. Which is at tab 18, page 261, and that's the relevant part is electronic 481. Under the heading in this article, comparative law. And we have the extract that I just took you to, my lord, first of all, and then the unidroit principles, where in that particular code, equity comes in, and then we have the DCFR code, where it says this: a term of a contract requiring any agreement, modification of its terms, or to terminate the relationship resulting from it, to be in a certain form, establishes only a presumption that any such agreement is not intended to be legally binding unless it is in that form. And I would submit that is essentially the position under common law, that we have the norma clauses. You can rely on the norma clauses if you want, and it's presumed that you will do. If you get into a negotiation and don't rely on them, and there's evidence to support that, then you can rebut this presumption. So that neatly reflects, we would submit, the position in common law as expanded and explained in Globe. Can I address the appellant's concerns? The appellant's main complaint is that summary judgment won't be available so readily to a party who says that there was not an oral variation. But that's not a concern. Where the evidence is so lacking, then summary judgment will be available. Where it is not, then it is proper that the matter should be determined at trial, because there is a true dispute between the parties. As Lord Justice Underhill said in Globe, this approach does not mean that there is no value to these types of clauses. They are enforceable. They form part of the context in determining whether there has been an oral variation, i.e. they go to issues of proof and evidence of the oral variation having occurred. And as he observes, the hill you have to climb to prove that there's an oral variation is probably going to be steeper and higher where these are included in the original contract. These terms are enforceable at law, but the parties can choose to override them if they want to. So they are only, the appellant says they're unenforceable. They're only unenforceable in those circumstances where there has been an overriding. And that is because they're no longer part of the contract. There's no evidence that any unmeritorious cases are being advanced to prevent summary judgment. If a party to a complex commercial contract asserts an oral variation without supporting contemporaneous evidence, they will not survive a summary judgment application. By contrast, here there was...
Really? What, without written material?
Sorry?
Are you suggesting that you never get leave to defend if you haven't got some written evidence to back up your suggestion that there was a...
No.
Sorry, in that case I misunderstood you.
No, I'm just saying there's a sliding scale of the evidence subject to the usual test. I did say that, my lord. So you didn't misunderstand me, but I'm wrong in saying that. That is too bold to say that. But they're going to have a real struggle. The ratio of the case in Globe is at paragraph 100. Which the appellant says is that is on page 92. In the hard copy and 288 in the electronic versions. This was criticised in oral submissions by the appellant as being flawed. The ratio there is parties have freedom to agree whatever terms they choose to undertake and can do so in a document by word of mouth or by conduct. The consequence in this context is that in principle, the fact that the parties' contract contained the nom clause does not prevent them from later making a new contract, varying the contract by oral agreement or by conduct. So it doesn't say, as advanced by the appellant, that you can never agree an anti-oral variation clause, a nom clause. Of course you can.
No, what he said was you can never agree an effective one.
You can. Of course you can. You can say, thank you for ringing me up. I've looked at the contract. There's a nom clause there. I'm not going to enter into discussions with you.
That doesn't give you a much better bargaining position than just saying, very interesting proposal, I'm quite interested, but I want to make sure for certainty's sake that it's reduced to writing, even if you haven't got a nom clause.
Yes, but the advantage of the nom clause is to say we're going to rely on that. We're not going to enter into any discussions at all, and any discussions that we enter into is subject to that clause. But if I don't want to rely on that clause because it's onerous, I don't have to.
Well, the trouble is, if you take the latter course, it's a lot less obvious that you have in fact done so. It's so easy to record something in writing
Yes.
that the ordinary inference that one would draw from the fact that the parties haven't done it is not that they intended to scrap the nom clause, but that they simply forgot about it or never paid any attention to it. So that it's not easy, when the parties have said nothing about the nom clause at all, to assume that it was their intention to dispense with it.
My Lord's right, but that's all matters of evidence. It goes
indeed.
through into the determination. That's not a matter of principle to say, oh, well, you can't vary the nom clause. That's just what evidence do you need to satisfy the court that that's what happened. My Lord's right that where there is contemporaneous emails, etc., that is going to assist in that process. It all ultimately comes down to a matter of and a question of evidence, rather than, as being advanced by the appellant in this case, oh, it's a question of law and you can't. Once you've put a nom clause like that in there, you can't ever avoid it. You always have to rely on it and you're always bound by it. And that would go completely counter to the basic tenets of contract law and the autonomy of the parties. Those are my submissions on the clause 7.6, and I'll turn now to consideration, which has been described as a difficult rule of contract law. And we do ask why consideration would be needed for a variation. There's a pre-existing contractual relationship, and this is different to a situation where there's just an obligation to pay a debt. In this regard, the recent extracts of Chitty that we've handed up may assist the court. Chapter 4, paragraph 67.
Remind me, who is the current editor of these paragraphs?
I don't know who is the editor of Chapter 4. I think it's Mr. Triton.
We're being referred to academic material. Probably we have all heard of Dr. McKendrick.
Yeah.
May even have recently met him.
I'll find out, my lady.
Dr. Morgan's slightly less familiar, but nevertheless fairly familiar. But if we're being asked to compare academics' views,
The editor of the Cambridge Law Journal.
Morgan.
Fellow corpus.
Yeah, that's right.
Oh, well.
That's right. But he's probably slightly less well known then.
Yeah, I'm sure it is.
It's Mr. Triton on Chapter 4.
Professor.
Professor.
Which bit of Chitty are we looking at first? Because I've got mine in 3 quite separate attachments.
Yes. It's not in the electronic
No, it's not. It's in separate, which I've also got electronically. But just give me the paragraph number.
Yes.
I can find it.
Chapter 4, paragraph 67.
67. Oh, I've got 65 and 68. It'll probably be in the 65 attachment, will it? No. I didn't. Hold on, let me try the next one. Yep, got it. It's in the 68 attachment.
It's got a heading, cases where there was no consideration.
Yeah.
And this deals with the seafaring cases and how the seafaring cases most probably would be decided on different principles now. The Stilker-Mirrick case.
Oh, this is yet another case that I've been mispronouncing all my life.
I probably just did mispronounce it.
Just reverting to a debate I famously had with Lord Panic.
Yes. Well, I call it Stilk and Myrick. I don't know
Yeah.
what it is correct, what the correct pronunciation.
Well, whoever taught me contract law called it Stilk and Marek.
Probably right. Then.
It's all lost in the mist of time, so who will know?
Yes. So they're out on a voyage. As part of the voyage, they contracted to man the ship even in emergencies. There is an emergency. They do a bargain with the ship's captain or master to get more money. They claim the money on return, and they're unsuccessful. One of them does, and they're unsuccessful because they're already contracted to do exactly the same. And the author explains that that was determined on the basis of lack of consideration. But
I mean, the modern answer to that problem would be economic duress.
exactly, and that's set out in the next paragraph at 68, where if, on the other hand, the promisee's refusal to perform the original contract does not amount to duress, the promise cannot be impugned merely on the ground that the refusal amounted to an abuse by the promisee of a dominant bargaining position. So that's exactly what they say, my lord, that these cases these days would be looked at as an economic duress case, that there, in the Stilk case, there was economic duress, but they'd already contracted, because it was in the middle of the Napoleonic Wars, and they were concerned about emergencies. Their original contract specified that they would get paid as well for emergencies, but in contrast, Ponsonby, which is at tab 4, my lord, and is page 101, hard copy, electronic copy at 299 and 300. This was similar on some of its facts. There's a long sea voyage. They dock into port. A number of the crew disappear, and the ship's captain is left with a reduced crew and attempts to get back home or complete the voyage. He does that by entering into a bargain with the remaining sailors. I'll pay you a bit more money to get me home and the ship home. Did that fall within Stilk and mean that there was no consideration? No, because this wasn't an emergency situation and it hadn't been contracted with the parties. There wasn't economic duress. He was doing a deal with the sailors, and he was bound to that deal when he returned home.
They were doing rather more than they'd contracted for. They were providing additional value.
They were providing additional value. I don't know how it would work in the modern day, how much extra work they'd have to do. But what was interesting about that case is they drew a distinction, because if there was an emergency on the voyage that resulted in them doing exactly the same additional amount of work, for example, instead of the other sailors departing in port, they were swept overboard, there wouldn't be consideration, and it would be in a Stilk and Myrick situation. But because they were in port, and they hadn't contracted for the emergency situation, then the captain was bound to pay. He couldn't say that they hadn't done anything additional, that there was no consideration. So those cases work perfectly now, and would work perfectly now under the concept of economic duress.
Well, it looks as if the ship, they may well have had a contract to work the ship short-handed, but not if it was so short-handed as to be unseaworthy.
And then, ironically, it was held to be unseaworthy, but they went to sea.
Well, they got there all right, but they took the risk, for which they were
took
paid
the-
extra.
Yes, they took the risk. Yes, that's right.
Plenty of unseaworthy ships actually get to port.
We've set out in our case, at page 92, the reasons why consideration for a variation is not needed. And I can summarise them in this way, that unlike an original contract, with a variation, there's already a binding agreement. The variation is just a modification of that agreement. It is not a complete rebuilding of the contract, but a refurbishment of the contract. The foundations don't need to be dug again. It's when you're just replacing the roof. And we would submit that all that's required for a variation is the party's intention to continue legal relations, because now we have economic duress as an adequate safeguard against abuse. I'll turn to the debt cases. In the debt cases, Folks and Beer, Reselect, etc., there is no original contract. There's one of the parties trying to impose a contract on the other party, even though they're obliged to pay the money already. We are in a contract case. We are not a debt case, because there was an ongoing obligation to provide the service offices. People in the 19th century and today would be amazed that Mrs. Beer got her interest. It's almost as if she's asking for, to continue the blood theme, asking for her pound of flesh. She enters into an agreement with Dr. Folks, and then, after everything's been paid off, she says, oh, actually, I'm also entitled to my interest. But of course, Shylock didn't get his pound of flesh, because blood would need to be dropped to get the flesh. And arguably, in the same way, the House of Lords could have held that the agreement that she'd entered into was the equivalent of the dropping of flesh. The second agreement was the equivalent of the dropping of the blood, and it should have been viewed in the same way. And they were obviously very concerned about extending the Pinnell rule further into, then it was 282 years, and now it's a lot longer. What is the Pinnell rule? It would be very difficult, again, for a layperson to understand what the Pinnell rule is. Pinnell is, if you're owed some money, £100, you can't agree to accept £80 to clear the debt, but you can accept £80 plus a chocolate wrapper to clear the debt. Lord Jessel says that's an extraordinary peculiarity of English law. And whether or not Lord Blackburn's commercial good sense would hold sway in a debt case now, it holds sway in a contract case, and we're within the contract case. The other extract of Chitty that I handed up is again in chapter 4.
By a debt case, you mean a debt arising otherwise than through contract?
Exactly.
I mean, contracts normally give rise to debts.
Yes, exactly.
I wouldn't distinguish the two in that way. What
No.
you mean is this was a debt to the Inland Revenue,
Yes.
to pay tax in Select Move, and Folks and Beer, it was a judgment debt, wasn't it?
Yes. There was no pre-existing contractual relationship, or if there had been, it had finished years ago.
But equally, there was no ongoing voluntary contractual relationship to affirm by the variation.
Yes. Exactly. That there is an obligation already, and one of the parties is coming along and trying to shoehorn that into a contractual relationship. But it isn't that. It's either as a result of a judgment debt, or in the select case, as a matter of statutory obligations, you have to pay your VAT. And that's why there may well be good public policy reasons, although I struggle to really understand why, where you have the benefit of a judgment debt, you're not allowed to agree, oh yes, 80p on the pound instead of 100p on the pound. But there may be some sound public policy reasons to require debtors to be held to the full debt. But that doesn't flow across into contracting parties. The contracting parties have an ongoing relationship with, and there's mutuality on both parties as to why they agree something. Well, it's going to be for practical benefit for them to do so. And that's highlighted by the other extract from Chitty that we handed out very recently at chapter 4, page 100, paragraph 119. Perhaps I can look at 118 first, which is at the front page of that extract. It says, the rule established in Folks and Beer may sometimes have performed a useful function protecting a creditor against a debtor too ruthlessly exploited the tactical advantage. But again, it's difficult now to rationalise the policy reasons. But turning to 119, on the other hand, it is arguable that the function of protecting the creditor in such situations now more satisfactorily performed by the expanding concept of economic duress than by relying on the Pinnells case. And that rule therefore no longer serves any useful purpose.
And how clear is it that whether or not the concept of economic duress will apply in any particular situation? I mean, whatever we think about the doctrine of consideration, we do mostly understand it. When is economic duress going to apply? How would you sum up that rule?
In a situation where one party is not willingly entering into a mutual agreement, in a contractual,
rather compelling reasons.
Yes.
in a contractual scenario.
Yes, but obviously he's done it, hasn't he? So think about what is it that makes him do it.
I think the test in the Sibone and the Simbotry, probably still the leading case, is that whether the will of the contracting party has been overborne, whether he had no reasonable alternative.
And if you're a creditor, you should arguably not have to rely on it, but you can negotiate, say, I'll take 80p on the pound on that debt. I know I've got a judgment debt for that amount, but I'll take 80p on the pound and do that willingly. But with Pinnell, that's not binding unless you also accept a chocolate wrapper. It's said in paragraph 119 that a factual benefit of a similar kind has been accepted as sufficient consideration for a promise, and the law will be more consistent as well as more satisfactory in its practical operation if it adopted that same approach in the relation of part payment of a debt. Agreements of the kind here under discussion would then be binding unless they had been made under duress. But we don't need to go that far in this case because the Folks cases are distinguishable in exactly the way that my lady mentioned, that those are cases where there's just the debt, there's not an ongoing contractual relationship. So it is distinguishable.
Why should it matter whether there is an ongoing relationship? In a sense, the advantage, e.g. to the inland revenue, where there's no ongoing relationship in relation to the same matter at any rate, or the advantage in Folks and Beer, is that you've got a better chance of getting your money without having to embark on litigation.
Yes.
Now, if that is consideration, it's hard to see why it shouldn't be consideration whether the relationship is about to come to an end or it isn't.
We would agree that they are very difficult to rationalise, those debt cases, and the underlying policy behind fettering the ability of the creditor to take less money.
Well, the rationale seems to be that the advantage has got to be in the terms and not in the practical benefits.
That's right. The way round that the creditor can do is to incorporate it within the contract.
Well, no, I mean, the rationale of Folks and Beer seems to be that no advantage, however great, can constitute consideration unless it is an advantage in the alteration of the actual terms of the agreement, of the obligations or benefits under the terms of the agreement. You look only to the terms of the agreement and not to the practical implications of the variation for one party.
And I suppose there is a logic to that in distinguishing that from contractual cases, because with the creditor-debtor, that's really all there is between those two. There isn't the ongoing contractual relationship and all the mutual benefits that are applying.
But the mutual benefits in an ongoing relationship, in facts like these, are going to be exactly the same as the ones provided for in the contract. So I don't see why it makes any difference that there's an ongoing relationship. If it's an ongoing relationship under unchanged contractual terms, but simply with a greater assurance of one party performing it.
Because, and I'll come to this in due course, that we're faced with an option at a later date after the beginning of the contract between, unlike the debt cases, between doing a deal or terminating. There are manifest reasons why they might want to do the deal that go, as you were discussing before lunch, beyond the contract between the parties themselves. They've got an ongoing relationship. For example, in our context, it's serviced offices. So having someone in the service offices, paying them money, it's much more likely to get their fee, their license fee, but there's ancillary benefits to having occupation of the property, to say we've got this amount of the building is let out, affecting their capital value, etc. And additionally, unlike the debt cases, there is a situation where it isn't certain what the liabilities between the parties are until the debt has been made by the court, judgment has been made by the court. It may be that the licensor considers that they'd be entitled to have the license fee for the remainder of the term. But they wouldn't be, because they'd have to mitigate their loss if they terminated early, and that's exactly what happened in this case, that they asked for rent up until termination and beyond, but rent beyond was not granted by the trial judge correctly. So that's how they differ from the debt cases. Paragraph 119A is the author's comments about the case below. And I just want to address one thing that has remained a puzzle for the author, but doesn't remain a puzzle for us. At the end of the commentary, where it says, the final paragraph says, the remaining puzzle arising from this part of the reasoning of MWB case is that the defendant's continuing in occupation was regarded as a benefit to the claimants, in spite of the fact that, by locking the defendants out of the premises, the claimant had shown that they did not themselves so regard it. Well, we can answer that by saying, well, it was a view of the person with authority that there was a commercial benefit at the time of the agreement, not at the time of locking out. Then later on, 30th of March, someone else in the organisation, and we've seen that, they were trying to resile from the agreement from the 29th of February onwards. then effect. So that is not an accurate summary of the position of MWB. There was a commercial benefit. Someone else disagreed with that. And it was a matter of commercial judgment on the 27th of February or on the 30th of March. There was actual consideration in this case. At the time of the variation, there was the prospect of future performance of a commercial benefit, which is a commercial benefit to the other party, and all the other practical benefits that we identify in paragraphs 48 to 51 of our case. Unlike the debt cases, the real benefit to the bird in the hand, and in contrast to just the one bird in the bush. It's not two birds in the bush, because the debt cases, it's certain, it's one bird, and it's either in the hand or in the bush. And in the contract cases, it's certain, it's better to have the bird in the hand doing a deal with the bird than the bird flying away. You're not going to get more. There's not going to be two birds in the bush. It's just going to be the one bird, either cooperating with you or flying away. The void is avoided. The prospects of full recovery are much better with a cooperating party than one who is not. In this case, if the license had been terminated early, the appellant would not be able to recover the full fees for the full term, whereas the prospects would be much higher with a cooperating respondent. That is a choice that's a real, or was of real benefit.
When you say not able to recover, you mean not in practice able to recover, or not as a matter of law able to recover?
Or both, really. I meant as a matter of law, because once you've terminated the license, you're not entitled to the monies for the rest of the term. They went to court asking for that, and that wasn't successful. There was inbuilt consideration, we would say, in any event. Agreeing to vary, the agreement to vary is the consideration, promise from both contracted parties to be bound by the varied terms. Take up another of Mr. Darton's invitations, this time made to the Court of Appeal, and confirm, please, that practical benefit is not just limited to cases where there's a contract for services and to the specific facts of Williams and Roffey. The choice we would submit on this limb of the appeal is a narrow interpretation of Williams and Roffey, which restricts the common law and rolls it back 30 years, or keep the status quo, which is slightly unsatisfactory with practical benefits being uncertain, or update the common law and row it forward. 400 years for the debt cases, 200 years for the contract cases to reflect the modern world. Can I address the appellant's concerns on consideration? The extent of the commercial benefit was irrelevant. Adequacy of consideration is not a factor for the court. The judge did not need to consider that. The revised payment schedule was a real benefit when choosing in a contract case between, at that time, termination of the contract or variation. There's no economic duress. You're given these two options. Which one is going to be good for you as the licensor? The trial judge properly dealt with consideration. It was specifically raised by the appellant. He did not need to look at the debt cases to reach his decision. The variation built on and was parasitic on the original agreement. So it's not right for the other side to say that the variation only required payment of the license fee, and that was already incorporated in the original agreement, because there was also a requirement to provide the offices. When he says there was always a practical benefit, he's probably right. He's probably right. There often is, very often, a practical benefit. He's right to say the peppercorn is imposed by the court, but that's a concept. The parties have agreed the practical benefit. if we as lawyers want to call it a peppercorn, to confirm the rules of consideration, we can call it a peppercorn. But it is just our nomenclature. It is not the court inventing the peppercorn and placing it into the agreement, because it's already there. There's already the practical benefit to the parties. The appellant states that the globe could have been decided on the basis of a collateral contract. That's at paragraph 63 of their case, and that is exactly what Lady Justice Arden found in this case. And that analysis of a contractual contract applies in any event. There was consideration for that contract, including the entering into it.
Well, doesn't consideration for the alleged unilateral collateral contract stand or fall with whether there's consideration for the variation?
No, it's slightly different, because there is, for that contract, the consideration is just entering into the contract. And so that can stand.
Consideration is entering into it?
Yes. The promises of both parties to be bound by the second agreement. If that's viewed as a freestanding...
If in the second contract you were simply agreeing to do what you were already obliged to do, what's the consideration?
The consideration is entering into that agreement, if it's viewed as a collateral agreement. So the appellant's submissions don't, even if the appellant's submissions had any traction on clause 7.6 and consideration, the collateral contract analysis would be an absolute answer. Thus, this judgment by the trial judge was firmly based on established legal principle and clear findings of fact. There was one modification made by the Court of Appeal, the effect of clause 7.6. For the reasons we give in our case, at paragraph 54, which is at page 95 onwards, the Court of Appeal was correct and the appeal should be dismissed. On both limbs of this appeal, the courts below chose the new world, which is also the real world, and so we submit, should this court. Those are my submissions.
Thank you very much indeed, Mr. Patrick. Ms. Whittington, do you find?
My lady, my lords, just a few points by way of reply. One, and I recognise to a degree I'm giving evidence, so I shall do my best to try and show where it is in the existing documents. A point was raised in relation to what entitlement we had to recover under the licence fee on our re-entry, if I can use that in its colloquial sense. Our response was that we were always entitled to recover under the licence fee, notwithstanding re-entry. What in fact happened was we, again using it in its colloquial sense, re-let following the re-entry, as a result of which we were not claiming the full term of the licence fee. I have documents that were in trial bundles which aren't before you, but what is before you, and so I hope you will accept for me is in a sense evidence of that, is that within the core bundle at page 157 on both, so electronic and paper, you will see there that the trial counsel at paragraph 25 records in the last sentence the future loss of licence fees has been mitigated by C. So,
yes, well, I mean, we looked at Judge Maloney's order, and we obviously were interested to see what the damages were. And we've got that where, Mr. Darton?
20, sorry, my lord, it's
20-odd thousand. It's at 127, isn't it?
Yes, my lord.
I'm afraid I don't know the other number. 21,000. And it wasn't immediately clear to us how that was calculated. Are you saying that was calculated up until the end of October, but giving credit for the relicense.
Yes, that is my understanding, my lord.
I see.
Yes.
Well, that's not quite the way that Mr. Paget described the outcome.
No, my lord. And it is a consequence of us, for the purposes of this appeal and not appreciating that this issue might be live, we've cut down on the documentation.
But does not the answer to this question simply depend upon the application of settled law to the terms of the licence agreement, rather than what the parties chose to do and plead thereafter?
Yes.
And the licence agreement, I assume, is, well, it is. In the
Yes, it is, my lord, but if I might develop that, of course, that is the correct position. You will forgive me for not being able to resist explaining what in fact occurred.
Well, you can if you like, but I'm just not sure why it butters any parsnips.
But, well, I think where it might have an implication for the appeal is that the moment you step beyond contractual terms to look for practical benefit, the moment that you say, as is being said against us, well, you were avoiding the void, you didn't want the premises to be empty, then you end up engaging in what factually happened. And you also, whether you regard it as a subjective practical benefit or an objective practical benefit, you have the fact that in this case, the judge has made no findings, as one can see in Williams and Roffey, that the appellant actually regarded practical benefit in the ways that have been suggested, developed by the Court of Appeal. So the moment you step beyond strict contractual terms, as my Lord Sumption was investigating or raising, then you are going down a factual inquiry. And the question you then have is that an inquiry which the judge makes based on his or her view of the transaction, or is it one that reflects what the parties themselves thought, or a mishmash between the two? And so practical benefit creates uncertainty, and I think some of the academic articles that have been cited refer to that. And that was my observation in respect of, or one of my observations in respect of, why extending practical benefit can result in effectively putting an end to consideration.
I certainly, speaking for myself, I certainly thought that it was relevant to Lady Justice Arden's point about avoiding the void, that you were, if it be the case, entitled under this agreement to your fees up to the end of October, and that giving the appropriate credit for what another licensee paid, that's what you got.
Yes.
My Lord, if I could help Lord Wilson with that specific inquiry. I've got paragraphs 11 and 12 of the particulars of claim. We can copy those. Paragraph 11 seeks rent up until May. There was a notice served at March and then it expired in May. And that seeks, once credit is given for 8,500 deposit, of 21,302. You see that that is immediately reflected in the order that you're looking at. Paragraph 12 seeks licence fees up until October 2012, 27,000. That is not in the order.
Well, there we are, Mr. Darton. That's a bit of an answer to what you were instructed 5 minutes ago.
Well, my Lord, and it is difficult. I wasn't trial counsel, and we're
No.
both, and I don't have any of the parties that were present, as it were, to that hearing. I mean, I missed.
Well, there it is.
But there is a response which is in relation to the order that was made. If your lordships and ladyship will forgive me for one moment, is that I think there's a distinction drawn between the 21 and the future loss.
Yes, there is.
And the limitation on the future loss, I'm told, reflects the credit that was being given.
Well, that's in the bit in the skeleton argument that you showed us earlier, that the future loss had been mitigated by the claimant reletting the
Yes,
the premises.
But that was in relation to future loss going through to the 1st of November of that year.
Yes.
There was no claim beyond that. So,
So, in case it matters, is it common ground that under the licence agreement, the claimant was entitled to the fees up to the end of October, whether or not they'd locked the licensee out?
we had understood that to be so. In the Statement of Facts and Issues, we referred to, I think it's clause 215. But yes, and I do have, at least I can respond in one way positively, I do have, I think, what is a more legible copy of the terms of the contract. What I fear, though, is offering to hand out one copy to copy it will simply return to the problem.
Well, I could just about read the original one if you can remind me what the electronic page number was. 139.
I'm grateful.
Some of it's legible, provided you blow it up.
Yes. Well, I got a very big screen.
But
What clause is it?
215, I'm afraid, now I'm going to have to...
Right, here it is.
Looks like it.
Now then. Not all legible.
No, it isn't all legible. That's
Which clause is it?
215, 2.15.
215.
2.15. Sorry, could you give me the page number again?
It's 139 electronic. Where is 215?
Well, why don't you read it out, Mr. Darton?
I shall do my best, my lord.
Mine seems to
This licence may be determined by MWB immediately upon the licensee's breach of any of the licensee's obligations under this licence. Whether or not this licence has been determined, MWB shall be entitled but not obliged to retain any of licensee's furniture, personal effects or other belongings present at the accommodation until all arrears owed to MWB have been paid or other losses made good. In the event of non-payment within 14 days, MWB shall be entitled to dispose of any such goods in settlement of any arrears and cost of disposal. And licensee agrees to and shall indemnify MWB against any losses, expenses or claims MWB incur or suffer as a result of the exercise of MWB's rights under this clause. Now,
Well, that's not very clear, is it?
well,
I
submitted
talked about
it's-
arrears.
I would submit it is clear enough in the context that, because although we use the term re-entry, there isn't actually a right to a specific area, and this was the landlord and tenant point. So I did preface my use of the word re-entry by in a colloquial sense. So the classic forfeiture scenario in landlord and tenant doesn't necessarily apply here. The opening contractual obligation is to pay rent for the term.
Well,
So-
I don't think you can take this much further
I
forward,
don't,
Mr.
my
Darton.
lords, I don't think I can, and
No, you can't.
I apologise for not being able to.
Don't worry.
But what I think I can say to you is it does indicate the degree to which the judge's findings of practical benefit were, in my submission, effectively undertaking the exercise in reselect move of stating the obvious, and you will see how he puts it in terms of hope at various parts, rather than finding actual practical benefit, as was acknowledged in Williams and Roffey, and therefore so easily seen. But my
I think
lords,
the
there
answer
it
lies
is.
in clause 2.10d, if I may say so. Because the licensor has a right to terminate the licence. In such event, licensee will remain liable for licensee's obligations previously accrued. Anyway.
My lords, not least is my difficulties. I too having trouble reading this, and I'm
Yes.
grateful to you. But so I can't take that any further. But if I could just respond to the points that Right. I'm instructed, my lords, if I could just say that in relation to page 127 of the core bundle, the figure for future loss, which is £1,190 and 5 pence, that reflected on the judge's part an acceptance that we could recover post re-entering. And the reason it is a lesser sum, and one can see what the figures would be, is because we gave credit for the reletting.
You said that.
Yes, I'm sorry, my lords, I'm a creature of instruction, even in this tribunal. So, my lords, can I therefore just, in the very few points of reply, the issue of economic duress was not one that I did address you on, but I would obviously adopt the points that have been made as to how it applies, because it isn't an easy test, but it is a test that this court, or certainly some courts, will be obliged very quickly to address if consideration is removed in the way contended for by the respondents. The next point I'd like to make is in relation to Folks and Beer, is that if I can use this term, whilst every note has been made of Lord Blackburn's observations that in a sense he'd wanted to give a dissenting judgment, but hadn't, I think it is to be noted that their lordships who didn't express themselves that way did so aware, as it were, of the bad smell of consideration. If you read Earl Selborne's speech, they are not saying that they do not see the problem, but how Lord Selborne put it, and I would contend it's the point that I've tried to make, though less elegantly, is that, and perhaps if I could just take you to that, and I think it'll be the last decision I do, just take you to it quickly, which is page 238 of the electronic copy, which is core bundle, authorities bundle 1, tab 2, is that you see there that, at the first full paragraph of 613, a lot of the criticism, even that has been made of consideration, even then is recognised. But Lord Earl Selborne's conclusion, I submit, if one moves down the page to about a third up from the bottom, is that to have allowed to find consideration here, he held, but I think it is impossible without refinements which practically alter the sense of the word to treat such a release or acquittance as supported by new consideration proceeding from the debtor. So it's not that they don't smell the problem, it's that it's a consequence of the definition, which is what I hoped I tried to set out this morning. And so I say, the fact that Lord Blackburn put away his intended judgment supports us rather than detracts from us, because they weren't prepared to do away with consideration, and they certainly weren't prepared to do away with it by what I've termed the back door. My lords, in relation to the distinction between debt and contract, it doesn't seem to me to be a real one. The problem with it is that so far as I can see in Folks and Beer, there was a contractual liability. Once judgment is given, the contractual liability merges into the judgment and it becomes a debt. I can't see any distinction there. The continuing relationship seems to come out of, I think it was Lord Justice Russell, as he then was, observations in Roffey, but they're not supported by the other two Lord Justices. And I don't myself see that there is any basis for drawing a distinction in that way. My penultimate point is in relation to Globe, that what doesn't seem to be present in Globe, I've done my best on the authorities to, is that there was any pleaded claim based in estoppel. So therefore, the court was obliged to deal with it in a contractual way. So whilst my learned friend is right to say that there was some, and it appears to be an only oral argument as to the question of estoppel, there wasn't a pleaded claim. And you have my points as to the way the case could have succeeded on that limb. My last point is simply to return back to the questions of policy reasons. And to, if your lordships will forgive me, just remind your lordships of the fact that the policy reasons that I outlined at the beginning and have been raised in my learned friend submissions, they appear at paragraph 97 of Globe, which is page 92 or 288. No one, I would submit, has gainsaid those. They appear to be accepted as powerful reasons, and you see that repeated in a number of judgments. In particular, in this case, in MWB, at paragraph 28 of his judgment, Lord Justice Kitchen described the recognition of these policy reasons by Lord Justice Beatson in Globe. So whatever else is thought of the argument that's been made on this side, the policy reasons have not been impugned. They weren't impugned below in this case. They weren't impugned in Rock. And you are being asked to, as it were, uphold a decision where the policy is acknowledged to be almost, if not entirely, one way. So, my lords, unless I can assist further, yes, my Lord Sumption asked a few points of me in relation to, I think, entire agreement clauses. The Lord does not seem to have moved on recently, so certainly Chitty refers to no new cases. Springwell looks at this estoppel by convention point, which we addressed. Beyond that, I think the most recent Court of Appeal consideration of it was the case of North Eastern Properties and Coleman, which was 2010. That was much more about the Law of Property Miscellaneous Provisions Act, as I can see, but it looked at the mechanism of entire agreement clauses. In other words, that they are based on the contractual estoppel, not in the truth of the factual circumstances. The other point that was raised was in relation to waiver and estoppel.
You referred me to Chitty on that.
Well, I did, my lords, and just as it would have it at this very moment, my laptop has just lost its power because I did address this in the skeleton argument that I submitted to the Court of Appeal. And my understanding and the written argument that I presented to them was really based on paragraphs 4-82 of Chitty, and then
4-082.
yes, and the other
Is that
passage.
is that the bit where it is suggested that the doctrine of waiver requires a degree of reliance?
Yes.
Very well.
And in effect, that it is, some have suggested it's another form of estoppel, and that is how we set out our stall in response. So that's how we've dealt with that. So, my lords, I apologise for the loss of the power, but those are the responding remarks for the appellant.
Thank you very much indeed, Mr. Darton, and thank you to everybody for very interesting and helpful submissions. It's a great joy to this court to get a straightforward common law issue to determine, but of course we don't often get one as fundamental to the law of contract as this has turned out to be. So we will go away and put the wet towels around our heads and necks and try and work out what the answer is and let you know in the usual way. Okay. Court is now adjourned.